Yes, good evening to everybody. The class of the Advanced Private International Law, Karibusana. Welcome to the class. And today that we are going to deal the transfer of property conflicts. And when you know it, there is no dispute at all for the immovable property. Why? Why? There is no dispute for the immovable property. Why? Give me the answer. If you don't know, say pass on. If you don't know the answer, you say pass on. I repeat.
Network is I can hear you well.
If you don't know the answer, you say pass on. There is no dispute for the immovable property in
I
conflict of
cannot hear
laws.
you well, sir.
Yes? Say. Say your problem. Dorcas has now joined, at least she will speak. There is no dispute at all for the immovable property in the conflict of laws. I repeat, there is no dispute of the conflict or conflict for the immovable property in private international law. Why? Dorcas, if you know it, you tell me. If you don't know it, you say pass on.
Repeat the question, Prof.
There is no dispute at all in the private international law for the immovable property. Why? And which country law could be applied? There is no dispute at all. Is it any dispute? Who is your mother? Who is my mother? Yes?
Pass
No,
on.
no,
Prof.
For immovable property, there is no conflict in private international law that which law could be applied. The connecting factor is lex situs, where the property is situated, that country law would be applicable. Repeat.
There is no conflict on immovable property because the applicable law will be where the property is situated.
Under the private international law, there is no dispute who is my mother and who is your mother. Is it clear?
It is clear, Prof.
Why it is clear? Tell me. Because
Because the mother is always known.
mother, because the mother give the delivery to us and everybody knows, and hence there is no dispute at all who is the mother of a baby boy or baby girl. In the same manner, there is no dispute under the private international law for the immovable property, which lex cause, which could be used over there. Lex cause would be used over there, that country where the property is situated. Is it clear? Is it clear? Say yes.
Yes, Prof.
Very good. How many ways that property can be transferred? Anyone? If you know it, you tell me. If you don't know it, you say pass on. I repeat the question.
It can be transferred by sale or deed of gift.
Only two methods. In the transfer of property, the property can be transferred by the 5 ways. Number 1, sale. Number 2, lease. Number 3, mortgage. Number 4, gift. Number 5, will. Repeat.
Property can be transferred
There are 5 ways of transferring a property.
Namely,
by sale, by lease,
By mortgage,
by mortgage, and gift.
yes. But the thing is, in the mortgage, only interest will be transferred. That's only the thing. So, in the private international law, we don't use the other laws except the theories, except the principles, except the connecting factors, and some of them, but we use only the domestic law. We use only the either of this country or the foreign country. Only domestic law you will use it. So now just I will show you that how a transfer can be taken place in general. Number 1, sale deed. The most common way of the property transfer is through the sale deed. A person sells the property to another and then sale deed is executed between the two parties. In the sale, what is the criteria? Criteria is money. Either partly paid or fully paid. Doesn't matter. Once the sale deed is established, sub-register office, of course here also a land register is there and it will be registered, and there is a stamp duty you should have to pay on the value of the property, and next it will be transferred to the buyer. Of course, there are rights and duties of the seller is there, buyer is there, and we have to disclose whatever the facts should be there regarding the property. And thus a property can be transferred through the sale. So despite being the most common straightforward method, it is not really a cost-effective way of transferring the property. So there is no at all hitch should be there if you are a owner of the property. Is it clear? Say yes.
Yes, sir.
Can you sell the Kilimanjaro?
Yes, sir. No.
Why? I say why? Because you are not the owner of the Kilimanjaro. The state is the owner of the Kilimanjaro. The archaeological department or tourism department is the owner of the Kilimanjaro. A separate body is the owner of the Kilimanjaro. Is it clear? Say yes. Is it clear?
Yes, Prof.
Next, gift deed. A gift deed is generally
Yes,
given to a blood relations. Mostly blood relations only that you will give that. Of course, there are laws are there how it can be given and who will be entitled for that one. Then in the form of a gift. Don't say gift. Don't say gift. Say gift. That is the right pronunciation. So when compared to the sale deed, it is a better method as there are no taxes to be paid if the gift is made to the relatives, because of the gift duty, gift sale, it is stamp duty is very much less. And that's if the father and mother going to give the daughter or the son or any blood relation should be there, they will give the gift deed, because the stamp duty is less. Okay. So here there the stamp duty and registration charges will be paid to make a transfer legal. Also the kind of the transfer is irrevocable in case of the gift made to a non-relatives of course the amount would be high because it is not set with the gift deed. So that is one mode of it. Then another mode also there, a relinquishment deed. That means the above mentioned ways work only when the property is a question has a single owner. So what happens when a property has been multiple owners? Suppose the property father died, only sons are there or daughters are there, but daughters are very well off. They are tajiri, they are business tycoons, and they will relinquish it. Okay, my brothers are very poor, you enjoy the property. So the above mentioned way of the work only to the property is in a question of the single owner, but when the multiple owners are there, one of the owner wants to transfer the shares to another owner, such a transfer happens through the relinquishment deed. They say, I don't want my father property because I do have a lot of property, me. And they will put it in writing. The relinquishment deed, they will give it to the other brothers, those who are poor. Is it clear?
Yes, sir.
When there are multiple owners are there. So relinquishment is the surrender of one's ownership. Voluntarily surrender, not at the gunpoint. Voluntarily surrender the ownership in favor of the co-owner, other brothers or sisters or anyone. The stamp duty is applicable to only the portion that is relinquished and not in the full property value. Whatever the property is relinquished, stamp duty will be made only to that extent, but not the full property of the property, because we have to relinquishment, we have to pay the stamp duty. Now let us see the will. What is will? Can you give me the, what is will? Yes? It is nothing but a legal document, a paper document, where you want to give after your death the property to your sons, daughters, wife, and other distant relatives. Is it clear? Is it clear?
Yes, Prof.
Can I make the will, my entire property, to the charity? Answer.
You can,
Yes,
but it won't be proper.
You cannot give the entire property to the charity when your wife and children are there. The wife and children will file a case. We on the roads. My father wants to give the entire property to the charity. You are not supposed to give. But the law says, I don't know the Christian law what it says, but the Hindu law says you can give the entire property in the will to any other person. But only theoretically it is possible, not practically. Like theoretically, a Muslim can marry. A Muslim can marry
4 wives.
more than
4 wives. Is it practically feasible now? Did you see in the Mohanza he is having now 4 wives? Give me the answer.
no,
That's why I told
no,
you,
sir.
theoretically it will be there, but practically it is none. But Muslim law clearly says you cannot give the will more than 1/3. I repeat, Muslim law says, Sharia law says, you cannot give the will more than 1/3. Okay, now let us come to the point here. So a will be given by drawing the will. The recipient of the property through the will is not bound to pay any taxes. No taxes should be there. A will can be revoked or replaced any number of times during the lifetime of the person drawing it up. What do you say the terminology? A person died without writing a will. What do you say the terminology?
Intestate.
Intestate. Very good, appreciate. After the death, all that will is now only after the death of a propositus, means owner of the property who wrote the will. After his death. After the death of an individual, a successor needs to apply to the concerned civil authority with a copy of the will. Of course, the same municipal procedure. Same municipal law would be applicable. That is another way of the 9. Another way of the where you can get the partition of the deed. You know the partitions, brothers and sisters are there, they will partition it. That is called mutation. And they will make the share. In the Muslim law, a woman will get 1 share and the son will get the 2 shares. And here the partition deed also be there. When the father is left over there and he did not make the will and there is no distribution of the property, and the partition should be made by the revenue department here, and they will make it out, and later on that you can register on your name the portion that you want to have it. Suppose if you don't want to have such a portion, if you want the money, okay, you can transfer that thing. Okay, you take this property and give me this amount. Yes, that also could be done, and the property will be transferred in that way also by relinquishment, by taking the amount, not voluntarily, without making anything. So this way also it can be transferred. So now we will see will and the testament, making a valid will in Tanzania. And what is a will? Can anyone unmute and read? Quick.
Will and testament, making a valid will in Tanzania. What is a will? A will is a statement which is voluntarily made by a person during his lifetime to explain his intention on how his property shall be distributed upon the death. A will can be of two types, an oral will and a written will.
Okay. But generally, the two types are there. Even oral will also be accepted, and a deathbed will also be accepted. Holistic will also be there. There are many types of the wills are there, but generally they will consider the oral will and a written will. So it is the owner who will make such a thing. After my death, this property goes to this man. This property goes to this. An oral will is also a type of will where the wishes of the testator, the one making the will called testator, and are not a written form. The testator only expresses his wishes verbally to the available witnesses on how his property shall be distributed upon his or her death. While in written will, the testator wishes are put in a written form signed by him or her, witnesses also be present, and who knows how to read and write, and who saw the testator affix his signature on the document. Means the witnesses are must in the written will, and it is the he or she who is the owner of the property has executed will by putting his signature, or if she is illiterate, then instead of signature, what do they take? Instead of signature, what do they take? Participants. If the testator doesn't know is illiterate, he doesn't know how to sign, then what would be the next alternative? Participants.
Use a fingerprint.
Why you are taking so much time to give the answer for that question? Fingerprints of your thumb. Of course, there is a variation would be there for ladies. I am sure that for ladies they will take right hand side, I believe. For the gents they will take the left hand side. But there is a rule is there, but I don't know exactly how. What is the rule here? Left hand or right hand thumb? Sir, irrespective of the lady or boy, they will take both the hands. Do they take both the thumbs? Give me the answer.
I don't know the rules, sir.
Yeah, but in India,
But
ladies are left hand or gents are no. Ladies are right hand, gents are left hand. Something was there. They will take it out. Of course, witnesses are very much present over there. But in the registration, they take the signature as well as they take the thumb impression also. Both the things. Thumb impression as well as the signature also. Both the way. So importance of the making a will. So generally, what is the importance? A will is made so that the people will not quarrel for the property. Is it clear?
Yes, Prof.
Suppose if a person doesn't leave the will, and after some time, no, the money makes the relations very bad. Because so long the father is there is no dispute at all. When the father is died over there, then the dispute starts. No, that house belongs to me because I am the elder. But that elder fellow is having a lot of property. What about the younger? Younger fellow doesn't have because younger brother is very fond of the mother. mother will take her care. Mother will give the shelter to him and give the money. That's why that fellow did not go to the school and did not pass, and he is very become a jobless man because of the mother affection towards the younger son more. And then they say, the elder brother says, okay, my brother doesn't have the money, no, better we will give him. Very rare people are there where they can donate their part to the brother who is not that much sound enough in the financially. Because ladies will play the important role. Why you want to give? Your another brother also there, he is not giving. Why you are giving? Are you following me?
Yes, Prof.
For every man's success, there would be a woman. For every man disaster, Sema. Sema. See, women are till today, when God also did not understand the women's behavior. Is it clear? Okay, now let us see. A property executed will allows you to specify exactly how you would like your estate handle upon your death. Yes, it is the father who can decide it. How much portion will go to the so-and-so person, how much bank balance will go to the so-and-so person, how much the property, mobile property go to the so-and-so. It is he who can take his own decision. And once the will is made over there, and it will be registered. Generally, the will, when they wrote it, no, they will not keep in the house, because if they keep the house, if the children knows it, they will having the dispute at all. Your father giving the will, the more portion to you. Now you take your father. You take care of your father, not me, because you are getting the more share. So when the will is written, it will be sealed and we will put it in the registry. After the death, only it can be, yeah, of course, there is a probation is there is a procedure is there, and the will be opened, and there is a dispute would be there, then court will appoint the administrator. If the female is there, administrator stricts, and there is a procedure would be there, and till the property will be distributed over there, the administrator will take care of it till the property is distributed. So these are the various methods. When there is no will, again the law will prevail over there. And here the law will prevail is Indian Succession Act. For Muslims, Quranic law, Shariat law. So that will be the play. So what I want to say is, for the mobile property, the deceased domicile will be taken into consideration. When the deceased domicile is taken into consideration, at the time, that domicile, country domestic law would be applicable. That's why I want to go through the details of what is the Tanzania law say about the will. Because the deceased is a domicile of Tanzania. What should a will contains? Generally, will know the name and so, the particulars, this will contain it. As a writer of the will, the testator, you must be at least 18 years of the age. Of course, you cannot execute a contract if he is less than 18 years. And you must have the testamentary capacity, must state in writing that you are a sound mind, definitely. And writing the will of your own accord, with your own intention, with your own desire. Read the third one. Read the third one.
A statement declaring the document as your will must be included.
Very good. So a statement declaring the document. What statement? They clearly mentions this statement or this document or this property will be included or excluded. He can make it out. Yes, next. Raymond, read the fourth one.
An executor should be appointed.
Who is the executor? If you know it, you tell me. If you don't, I say pass on. Both of you.
The one who should supervise the division of properties.
Who will make appointment of the executor?
A right of the will.
The testator can choose any person would be executor. And he will also choose, if he say denied or he died, next executor. But if the executor denied over there and there is no other executor, at that instance, any one of the man from the family can be an executor, provided other people should not make any objection. If other people making an objection would be there, then the matter would be settled in the court, then the administrator would be appointed by the court. Is it clear? Say yes.
Yes, Prof.
For the male, we'll say administrator. For the female, administratrix. Trix will come for female. Okay, fifth one. The document must be contain at least one provision that names as a personal guardian for a minor child. Suppose the minor is there, and at the time they will mention who will be the guardian for that one till the minor becomes major. At least one provision providing for the allocation of your state. Even a fetus in the womb, yes, he also or she also entitled for the inheritance. Or inheritance, no, in the will also. Because if not today and tomorrow that he is going to be born, so his share also be there. If it is clearly mentioned in the will. If the will is not written in your handwriting, typed, you must sign the will and must be attested by witnesses who are not beneficiaries and who saw the will signed by you. Suppose if it is a computer-based will or printed will, not handwritten will, at that instance you have to sign it, and when you're signing it, there should be witnesses should be there to make it out. Yes, it is he who signed it. So what is the validity of will? There are certain norms are there. The making of will is a vitally important act for reaching the consequences, since you can't take it with you when you die. Having a valid will is one of the few ways you can give back to those who love in proper or legal manner. And for instance, if the two wills are written by the deceased, which will be valid? I repeat the question. Two wills are written by the testator. Which will be valid or in force?
The
last one should be enforced. Please note the point. Generally, a will is not valid unless it fulfills the following requirements. What requirements? Legal age should be there, a person who is executing a will. Yes. Then he should have the capacity. Yes. Like the contract. And sound mind. Yes. In the contract also sound mind. But an insane man cannot form a contract and understand or he is disposing the property of assets. Yes. She knows what she is doing or what he is doing. And next, intent. What the person has an intent to make a will at the time of the signing, he or she intends to make a revocable disposition of the property in the event of his death. Before the death, he can change it. But after the death, no one can change it. But a will is written, but the property is sold. The will not be executed because the property itself is not in existence. So will not be executed and is not a proper will. So voluntary. A will must be voluntarily entered into and signed by the testator. Its own voluntary way that will could be written, not at the gunpoint, not at panga point. I will executed by a person who was coerced forcefully into a signing the will and who signed the will under the duress and the undue influence or the threat or by tampering is not considered to be a valid will. The proper disposal of the property, how it can be disposed. A will must be properly disposed of the testator's property. This includes listing of all the property and assets and property, distributing them among the friends and the family according to the testator wishes. For instance, if the testator funeral expenses are there, yes, that will be deducted. If the deceased medical expenses are there, it will be deducted. If it is attendant would be there, yes, it will be deducted. or someone at the time of the hospital, they are helped him, and such labor charges also it will be deducted. And later on, whatever the property would be left over there, that will be distributed among the beneficiaries. And who is the legatee? So proper disposal of the property would be there. Assets and property distributed in them, friends and families according to the testator wishes. What is his mentioned, according to that way it can be done. And appointment of executor, I told you, when the dispute comes over there, the court will interfere in the appointment of the executor, but already it is there by the executor, it is written in the will, and he is willing to do, then he will be an executor, unless until if he does anything wrong, then he can be removed. So, appointment of the executor, I told you, a will must name an executor. There is a person who will oversee your assets after you die and will make sure that your wishes set out in the will are followed. It is appointed by the executor, appointed by the person who who writes the will. In the one who is responsible for safeguarding your assets, administering any trust which may set up under your will, the executor will be responsible for the distributing all your assets to the beneficiaries. Who are the beneficiaries here? Who are the beneficiaries here? Participants.
Children.
Suppose children name is not there, then no, generally the wife and children would be there, their names will be mentioned. Sometimes you can mention the other person who take care of him at the time of his ill will. He also can give some amount to that person also, even though he is not from the blood relation. A sign dated and witnessed by the two persons who are not beneficiaries. A person who witnesses, he should not be a beneficiary. And generally, who are the witnesses means not the blood relations, generally. The other person, like Jirani, neighbors, yes. A will can be handwritten or written, or a single price of a paper, a piece of a paper, or elaborately typed within the multiple pages, depending upon the size of the estate and the preference of the testator. It must also be signed and dated by the testator in front of the competent witnesses. They say competent witnesses who must also sign. If the testator is illiterate, the written will must be witnessed by the four persons. Two of them must be a relative of the testator. Suppose if we give the thumb impression, at that instance, two relatives should be there from the testator family and the two witnesses from the outside. Total four persons should be needed when he is a illiterate and could not sign. Is it clear? Is it clear?
Yes, Prof.
See, in the Muslim law, there will be two witnesses much for the Hanafi marriage, Sunni marriage. The two witnesses among them, not necessarily the women. Two witnesses in the sense, two women is equal to one witness. I repeat, two women is equivalent to one witness. And one man is equivalent to one witness. That means two women should have to sign it and one man should have to sign it. Sir, can the four women can sign it? Give me the answer. Can the four women will sign it? Answer no. Even they are two witnesses, because two women, one witness, two women, one witness, two witnesses. But Muslim law says no. Only two women or one man or two men, but not four. But not four
Women.
women. So the
Prof, why is the law setting such a condition? Why are two women equal to one man?
one story I told you. The God knows what is the reason behind it. The story, when the BBC is there, body to body contact, both they will enjoy it. When the delivery is there, only women will suffer. I told this story to you. Did I? Did I?
Yes, Prof.
But Dorcas is silent. What did you learn by that story? Our thinking is limited. Is it clear? Is it clear?
Yes, Prof.
Who's thinking, Prof? Who's thinking?
Human being thinking is limited. I said human being, including the man and woman, everybody comes. There is a reason behind it. I told also, if you inform a woman any secret, I repeat, if you inform a woman any secret and you tell her, please don't tell to anybody because I am giving the information to you, it is enough. If you say such a word, even BBC will be late in broadcasting. Even CNN will be late in broadcasting. Even Al Jazeera will be late in broadcasting or telecasting. But this woman cannot digest the secret unless he will vomit it, tapika, tell somebody else, and she will relax. Sahasami mitoshasana. The reason is, it is inherent that a woman cannot keep the secret. The inherent quality is that a woman cannot keep the secret. Why? Of course, we don't know. Some women, majority of the women cannot keep the secret. If somebody gives the secret to her, and if you tell a proposition, adjective, don't tell to anybody because I am telling you. If you say no, if you don't say, at least she will keep for 1 day or 2 days. But she will definitely tapika. Najwa tapika. Najwa.
Yes, vomit.
Vomit. Dorcas is silent. See, the God knows what to do and what not to do because our human being, imagination, thinking, everything is sifuri, limited, though not sifuri. So they said two women is equivalent to one witness and one male is equivalent to one witness. In the same manner, property also, for the Muslim law, 2 shares for the male and 1 share for the female because she will be married and she goes to the husband family and the husband will earn and she will be entitled for the inheritance from the husband family also and she also entitled for the father family also. And hence they say, this fellow will take care of the entire family, wife and children, even parents, father, mother. If an unmarried girl is there, a brother is there, sister is there, this fellow will take care of him. And hence 2 shares will be given to this man. And 1 share, either the married or unmarried, doesn't matter. 1 share. Is it clear?
It is clear,
Yes.
Prof.
Very good, very good. I appreciate. So, we follow only the municipal law. But only the thing, which country law could be followed? For the mobile property, the deceased domicile would be law would be followed. For the immobile property,
Lex situs.
Lex situs.
Where the property is
Where the
situated.
property is situated, that law country would be followed. Okay, procedure law may be different. Either they can follow the procedure. Sometimes, if the procedure law says it's time barred, no. it will be exempted. Time barred is exempted. So revocation and amendment of will. Yes, a person, he can revoke the will, he can amend the will, or a supplementary will is called. Anyone? A supplementary
Codicil.
will is called
A codicil.
codicil. I appreciate a codicil. So he can make the codicil and he can revoke it, he can cancel it. And a codicil is a document that changes and revokes and amends a part or all of the validity. A will, generally part of the validity of the will, it can make it out. When a person executes a codicil that revokes some provisions of the provisions previous will, the courts will recognize this is a valid revocation. Yes, like a new will that completely revokes an earlier will indicates that the testator intend to revoke the will. If he wants, he can revoke the entire will also. It depends upon his intention. And sometimes revocation occurs by operation of law. As in the case of the marriage or divorce or birth of a child, the sale of property devised in the will, which automatically changes the legal duties of the testator. Yes, I told you in the foeters also, entitled, suppose my children will be given the equal share. Children, they said, not they say boy or girl. Is it clear? Say yes.
Yes, sir.
At that time it will be given over there. But in the Muslim law, it cannot be given in that manner. Because if he says that equal part should be given over there, the will, okay, only one third he can do so. Only one third he can do so. Even he can give the legal heir also. But when he is sharing the property, his heir, as per the Quranic heir, is as it is. Because this is additional. Is it clear?
Yes, Prof.
But if he wants to give more than one third in the will, he has to take the consent of the legal heirs. Of course, as Muslim law says. But in a Christian law, in the Hindu law, in other laws, no such a provision would be there. So further information, of course, he has given the administrator, estate, lawyers, and so on and so forth. We need not worry about that one. So what I want to say is, municipal law would be applicable in the wills. When the transfer of property comes, where the dispute comes between that one country to another country. If that, at the time of the domicile, which country that he belongs. If he belongs to Tanzania, yes, Tanzania lex causa would be applicable. If he is at the time of the death of, he is the domicile of another country, yes, that country law would be applicable over there. And that is, but we apply only the municipal law. But for the municipal law applied, who said? Doctrine said. Connecting factor says. Principle of right internal says. And treatise also says. The Hague Convention is there. Lugano Convention, Brussels Conventions, Berne Conventions. At least 5 conventions are very much important to note it. Recognition and enforcement of the foreign judgment, Rome Conventions, Warsaw Conventions, luggage, Warsaw Convention. So these are the conventions which will
Prof,
give it. Yes.
I have a question. What if a person dies without a will?
I told
Which
you no,
law
the Indian
will
Succession Act will be applicable. Indian Succession Act will be applicable even for the Christians also. But in Christianity, in the India, no. There is a the Christian Succession Act. The Indian, now they removed the Indian Christian Succession Act. And they said Christian Act. Yeah, it will deal it. For Jews, it is the Hindu Succession Act will not be applicable. But Indian Succession Act would be applicable. For Muslims, personal law would be applicable. When a person dies without a will, there are laws, personal laws would be applicable. In Tanzania, I believe that whether the customary law would be also plays an important role when the distribution of the property is concerned. Like land is there. In some clans, a woman cannot maintain the land. And she cannot dispose the land also. Unless until somebody would be there who gives the consent. So it depends upon the local laws of the country how the will be executed. But here I said it's the Tanzania only. A will and testament making a valid will in Tanzania. So without a will, Indian Succession Act, you refer it. Unless there is a
time working on social media for my clients. I create a lot of video content.